Yeah.
Couldn't
First,
understand, but
it is the chair.
yes.
The chair.
So welcome to our panel on civil rights. I'm Joana Morais. I'm from Lisbon, University of Lisbon. Thank you for the invitation to share this very interesting panel. Each of the speakers will have about 15 minutes, the same as the latest panel, and then the discussant will pose some questions, and then if we have time, we'll open the floor to the public. I'm sure we will. There has been a slight change. We will start with Andrés GASCÓN-CUENCA, who is joining us via Skype. He's from University of Valencia, here in Spain. He has a PhD in law, master's degree in human rights, democracy and international justice, currently working on the project Prometeo 2, and he's a director of the International Human Rights Clinic. His research interests include ethnic discrimination, freedom of expression, ethnic hate speech, and minority rights. His presentation is about the distribution of hateful messages through the internet and evaluation of the sanctions established by the Spanish Criminal Code.
So thank you very much. I think it is working, isn't it?
Yeah. Yes, it is.
So yeah, thank you. First of all, I would like to thank you, Professor Oscar Pérez de la Fuente, because I created him a lot of troubles because I had some last time problems that didn't allow me to participate in the meeting, like face to face, and he did all the possible to allow me to participate virtually. So many thanks, Oscar. Muchas gracias. And all of the team that organizing the meeting for making this possible. Is it possible to see the people on the table? Yeah, because I'm seeing my face and that's a little bit awkward. Anyway, moving to the contents of the paper I would like to present, which, as the moderator said, is distribution of hateful messages through the internet and evaluation of the sanctions established by the Spanish Criminal Code. The results I'm about to share are part of an ongoing investigation into the modification made to the Spanish Criminal Code in 2015 in reference to the behaviors known as hate crimes or committed against fundamental rights. Okay. These behaviors based on intolerance or hate crimes include a good number of articles in the criminal code that in our legislation we have like a mixed system to recognize them. On one hand, we have the Article 22.4 that generally aggravates any offense committed with a racist purpose, anti-Semitic or other type of discrimination regarding the ideology, religion or belief of the victim, ethnic group, race, nation to which the person belongs, related to the gender, orientation or sexual identity, gender reasons, illness or disability. And on the other hand, we have articles that specifically punish some behaviors like threats to collectives, offense against the moral integrity, crime of torture based on discrimination, discrimination at the workplace, hate speech, the Article 110, the Article 111 and the following that are denial of service provisions, illicit association, and also the 578, glorification of terrorism, and 179, incitement to commission of terrorist acts. The research I'm doing looks into the application of the Article 110, referring to hate speech crime, as I just said, and also the Article 178, glorification of terrorism, and 179, promotion of terrorist acts. The results, I'm going to present them very succinctly, like as the Professor Pérez de la Fuente said, I have a meeting after this presentation. Well, just an introductory work. Doing this research in this field is relevant as this regulation interferes in the fundamental right to freedom of expression, which I think we all agree is a fundamental pillar of any democratic rule of law state, but also it is an issue that is very present in our societies. So with reference to the Article 110, there will be much to comment on the new wording given from 2015 on. It is a very complicated wording. It's a really long article. We went from an article with only 2 sections to an article with 6 sections, whose differentiation is sometimes really hard to do. But one of the most complicated areas of this article is the jail times it establishes. According to the Article 3.2 of a framework decision of the European Council issued in 2008 on fighting against certain forms of manifestation of racism and xenophobia through criminal law, this article establishes maximum penalties of up to 3 years. Nevertheless, our Article 110 sets a maximum jail sentences up to 4 years. So there is no explanation about why the legislator have detached themselves from the decision of the Council, and it is even more worrying because it should be, I mean, the messages that are distributed, the hateful messages that are distributed through internet or social media had to have like a jail sentence from 2 years up, because it's considered as an aggravated circumstance. If one goes to the explanatory memorandum of the draft of the reform of the penal code, we can read that the intention behind the modification of this article is the framework decision that I just commented, with the aim of punishing 2 groups of behaviors. On one hand, and with a greater penalty, the actions of incitement to hatred or violence against groups or individuals for racist, anti-Semitic, or other reasons related to their ideology, they belonging to a minority group, as well that reasons related or intention to humiliate them. And on the other hand, the production or distribution of materials that by their content are suitable to incite to hatred or violence against minorities, the exaltation or justification of crimes that may have been, that they might have been objected, or the denial or apology or serious trivialization of genocide when this would favor hatred or violence against the groups mentioned. However, that's what it said. However, the reality shows a really different picture, where almost any offense, when almost any offense is intended to be pursued as a hate speech crime, without taking into account that it is an article that intends to protect members of a certain groups that by reason of their membership may suffer discriminatory acts that attempt against their fundamental rights, based, for example, on structural patterns of discrimination, or as, for example, the cases of xenophobia, racism, and other protected categories. In order to illustrate this reality, I'm going to put forward some example of cases that have been intended to be prosecuted via the hate speech article that I'm talking about. For instance, the supporting for the Catalan politicians that are in prison. A comedian that blew his nose with the Spanish flag. The Popular Party against the Socialist Party for the demolition of Francoism crossings in the application of the historic memory law. The Socialist Party against the Popular Party for a video in which a child asked to the Reyes Magos, I'm sorry, I don't know how to translate this this concept, to ask for, to Papa Noel or something like that Pedro Sanchez should die. Music concerts that speak about state terrorism, or that the state, that there exist state murderers, and there is that Spain tortures inmates in prison. Some tweets about Vox. I don't know if you know what Vox is. It's a political right-wing and extreme, a far right a political party. Some tweets made by representatives of this political party, or homophobic and racist tweets that they have put through Twitter. Political representatives openly denying what has happened in the Holocaust, and etc. So these are some examples of behaviors that had been intended to be prosecuted through these regulations. So what we are on a time that any offense to honor is intended to be solved by criminal law, forgetting that we have other jurisdictions that are really more effective to pursue this kind of behaviors, and even more because this means that we are forgetting the last ratio that is assigned to the penal order to place it in the front row of the battle in areas that are really sensitive to democracy, as freedom of expression and political debate. In this scenario, the largest volume of cases followed by the Article 110 are comments on social networks like Facebook or Twitter. And it seems necessary an urgent reform of the penalties that can be imposed by this type of action, in line with the case law of the European Court of Human Rights that repeatedly has decided that imposing jail time for this action is not appropriate because it breaches the proportionality requirements. Sentencing someone to jail time because that person has tweeted something, well, generally speaking, is not proportional. We can affirm that generally speaking is not proportional. We must bear in mind that the Article 110 punishes not just any offense to the dignity of the person. The act itself must have enough gravity to hurt the dignity, trying to generate a climate of violence. It's not just the hurting of the dignity, but to generate as well a climate of violence. So messages that try to foment or foster social confrontation by undermining the essential values of coexistence and equality on which our legal system is based. That on the one hand, but on the other hand, we have to admit, we have to affirm that not every message that we understand that distributes hate is found in this area. Not every message that distributes hate is likely to generate this climate of violence. There are messages whose content we can consider unacceptable, reprehensible, but that will not be relevant for the behavior from the criminal point of view. Moving forward, moving to the Article 178, its application is even more complicated because it's an article that punishes the glorification of the terrorists. Here we have the paradox that the majority of the cases followed by this article has occurred once the terrorist group ETA has been dissolved. The European Court of Human Rights considers that the limitation of the right of freedom of expression in respect of the glorification of terrorism are appropriate only when it can be inferred that such conduct poses a risk to national security, territorial integrity, or public safety, the defense of order, or prevention of crime. So, it is to justify. It is a discourse used to justify the use of violence to achieve political objectives. After warring sentences imposed in the Cassandra case, in the Titiriteros case, Cesar Strawberry, a singer, Valtonic, a rapper, the Constitutional Court has decided that the acts that should be classified as crimes and subject to criminal sanctions are those that constitute behaviors of exaltation or justification of terrorist acts or their perpetrators whenever, I repeat, whenever they act as an incitement, to commit violent terrorism acts that are typified in the penal code. I agree that this interpretation is adequate to avoid the punishment of behaviors such as those that I have mentioned, in order to avoid that someone is sentenced to jail time because he or she has tweeted, for instance, a joke about a terrorist group that we might find pretty despicable, but again, irrelevant from the point of view of the criminal code. This interpretation of the Constitutional Court also supposes to empty the content of the Article 178, since the Article 179 is the one that punishes this behavior. And it punishes who, by any means, publicly disseminates messages or slogans that are intended or that, by their content, are suitable to incite others to commit any of the crimes of the chapter that punishes terrorist acts. Therefore, in a future reform of the criminal code, I think, or I argue, that this article should be eliminated. So until then, this is my presentation. Thank you very much for listening. I hope my ideas are clear. I'm so sorry, but I will need to leave after the presentation. So if someone has any kind of question, I think my email is on the presentation that you can access through the web page. I think it's available over there. So please feel free to contact me if, as I said, there is any question. Thank you very much for allowing me to participate in the meeting, and that's it. Thank you very much.
Thank you, Andrés. So we will now continue with Jedrzej. We spoke before and he gave me permission to use this short version of his name, which is nicer to me. So he's from Mickiewicz University in Poznan, Poland. He's head of Department of Press Systems and Press Law from the Faculty of Political Science and Journalism. He collaborated with the Media Pluralism Monitor at the Center for Media Pluralism and Media Freedom from the EUI, and his research interests are freedom of speech, media policy, and human rights. His presentation is entitled "The Right to Freedom of Opinion and Expression in the Universal Declaration of Human Rights, a Contemporary Perspective."
Thank you very much. Thank you for invitation, Oscar. It's a great honor to be here and to share my outcome of my research on this level. I'm sorry. It seems that it's not possible to be full screen.
No, I think so. I think it's possible, but I don't know what is.
It's in Ver.
No. Okay. No problem. Yeah.
I think it's here. Although
Okay. Yes.
Oh, great.
Excellent.
Thank you very much. Okay. After 70 years of implementation of the Universal Declaration of Human Rights, key question is about this Article 19 of this declaration, because according to the article, freedom of speech is one of elementary and fundamental human rights. And in my opinion, Professor Sungurov, maybe this is not a religion, however, it's almost a religion. Such thesis we can find, in my opinion, in Article 19 of the Declaration. So after 70 years, as I mentioned last panel, it's good, occasion, a good opportunity to analyze this article, because what was changing during the last 70 years? We can say almost all. However, we still the old problems. Okay, we can mention, for example, globalization. However, I would like focus on digital revolution, because it seems that this is only technological process, technological or technical revolution. However, undoubtedly, it had a great impact of the media, of the functioning of the media and media system. Well, yes, next issue, next point is a question about internet. Is this a public, contemporary public space, public sphere, or not? The internet was developing in the spirit of freedom from the control, also at the beginning without any payment. Maybe it is also important according to the copyrights. However, we can underscore that while there are some difference in the way of using freedom of speech in public sphere in the traditional media, I mean about analog media and the internet and new or digital media. I mean that in analog media, while we had radio, television, printed press, and now everyone could be a broadcaster, yeah? And this is for example, one of the big the difference. Well, so we can even, in my opinion, metaphorically say that together with the development of the internet, we discover a new continent or even a parallel world. So, question is about how we should colonizate this area. Colonization of this area resembles conquering new areas in the times of great geographical discoveries, in my opinion. However, we have some big difference that this is a big, huge challenge for the doctrine of freedom of speech on internet, freedom of expression. I mean about non-territorially phenomena of this sphere. Yeah? This is a globally net without border. This is important, for example, from the legal point of view on legal action, because it is normally in legal mentality, while legal action is generally limited to the legal system in given country. So it appears that still law and legal system do not handle the challenges of the global space. Okay, once again, Article 19 of the Universal Declaration on Human Rights. Everyone has a right to the freedom of opinion expression. Yeah? This right includes freedom to hold opinion without interference and to seek, receive, and import information and ideas through any media, and regardless of frontier. Okay, it seems and it sounds great. However, in practice, what does it mean? Yeah. Because we can say that we have the new digital era. Okay, we discussed about some revolutions. We should maybe discuss about the digital revolutions now. The new digital era, but some old challenges. And this is a problem on this field, that we have the old problems and new challenges. Yeah? Because what does freedom of opinion and expression mean in the digital era? So, for example, one point, we can observe phenomena which we called commercialization and outsourcing of censorship. Okay, according to the declaration from 1948, public authorities have a duty to respect and protect our freedom of expression and freedom of information. And any restriction to the freedom must not be, of course, arbitrary. Yeah? Exception and restriction in this rule we can find in declaration in Article 29, clause 2nd. Yeah. However, according to Kurtlanzig and Link, commercialization of censorship, it means that while censorship now is outsourced to private media companies. However, even now, not only to the media companies, but to, for example, owners of social media. And what we can find on this field, well, okay, person from all the world, however, also, for example, boots, yeah? So we can say, or we should ask when we discuss about censorship of algorithms, yeah? So in this sense, we can also consider privatization of propaganda. It means that while the main actors is not a state or, well, authorities, however, the private organization, private groups, or even a single person. Yeah, and the big, huge question is about the role and position of internet service provider or provider of online content, and in my opinion, these bodies play important role as a private censor. Yeah? Of course, they should play in responsibility way, respect human rights, and provide mechanisms to respond to user claims. Everyone should be informed of possible restriction because, okay, we can agree that when this is a private space, okay, internet is a private space, media, social media are a private space or public space. This is a big question, yeah? So, however, for example, Google or Facebook, this is a private enterprises, private companies. So it seems that they have a rules to put their own regulation. Yeah. However, everyone should be informed of possible such restriction. Yeah. Yeah. Next point is when we consider internet as a public sphere, non-discrimination access to the internet. Yeah? This is very, very important, and in many cases, in many countries, we observed such blackout when authorities or private and companies together with authorities, switched off the internet in special time. So, question is that while maybe we should next rule that nobody should therefore not be disconnected from the internet against his her will. Okay, except when it is decided by a court. Yeah. Next point is potential dangers for association or public life participation in on the online sphere. Yeah. So protection of this right to peaceful assembly and associated with other using of internet should be protected by law and protected by result of analyzing the declaration. Next important thing is privacy and data protection and dangers on this field. Yeah? Protection of the right to private and family life on the internet. should include the protection of personal data and respect for confidentiality of our correspondence and communications. Of course, it's true and this is clear. However, the new media technologies provide technical opportunities for tracking and invigilating everyone. So, question is, according to Article 29 about restriction of freedom of speech in digital era. Sometimes very popular restriction is morality, public order, general welfare in democratic society. This is quotation for Article 29. Yeah? However, Oscar, I guess that will be presented problem with hate speech on internet. Yeah. So okay, we can agree that restriction on the field, I mean about discrimination, hatred, or violence, yeah, and hate speech, it's possible. Yeah. However, this restriction must be lawful and executed with court oversight. Yeah? However, we have here the problem because, well, once again, internet is a global space, global net. However, we still think in domestic area about, domestic legal system. Yeah? And this is problematic. Now, in Europe, is discussion about new European directive on copyright on internet, yeah? And many discussants underscore that while this is a kind of censorship, well, it's next. Key question because the internet is a space of freedom. However, freedom means anarchy or not. Next point is effective remedies. This is a big challenge for protection of human rights. Who will be responsible? Okay, public authority, national human rights institution, or private company. I mean, Google, Facebook, etc. Yeah? Few days or few weeks ago in Paris, while President Macron declared the so-called Christchurch Declaration, yeah? Against glorification of terrorists on internet. So this declaration goes to the private companies. However, the question is, who will be analyzed? This is a terrorist content or not? Yeah, independent court or private company. Next problem. Also, a few days ago, President Trump announced the new regulation against Huawei. Well, in the close future, it will mean that someone who has Huawei equipment will be out of order. This is a kind of censorship or not. So, time for conclusions. We can say the battle for human rights, freedom of speech, or maybe broadly freedom of expression is, unfortunately, a never-ending story. We have old problems and new challenges. For example, new media, I mean about everything what is online, plays a significant role of shaping and dissemination and content. And here we can find new new kind of censorship. Challenges and dangers for freedom of speech we can find also in action of Booth's algorithm. How to fight with this equipment? Yeah? Who will be responsible? Oh, we are sure that someone is a supporter of such algorithm. However, yeah, this is could be also problematic. Yeah, and disinformation. Sometimes we call this trend fake news. However, this is not correct term. It also plays significant threat to freedom of speech. Yeah. Why? Because well, this is also a paradox of well, freedom always. Last year I conducted a survey on the relationship between China and Taiwan. When Taiwan was under during the martial law, well, this island was according to the circulation of contents was safe. Now Taiwan seems that this is a I mean that this is on this level of freedom of speech in good condition. However, big neighbor, I mean about China, yeah, they has a big influence through, for example, private companies, because the Taiwanese market is open for other investors, companies, etc. And in this sense, we can say about the privatization of censorship in this region. I'm sure that we can find such examples in many other regions in the world. So, well, last sentence, as I mentioned, unfortunately, protecting of human rights, this is never-ending story, and I hope that nothing changes in the future.
Thank you.
Thank you very much.
So we will now go on with Oscar Pérez de la Fuente, which we all know very well by now. It's home. He's from Carlos III. He's associated professor since 2011. He graduated in law in Pompeu Fabra in 1994 and finished his PhD here in Carlos III in 2004. He is the author of several books and articles on cultural pluralism, free speech, and legal interpretation. For his presentation today, he raises a question: how can the internet change human rights on online hate speech regulations?
Yes, today my speech will be whether hate speech internet regulations will be the same online and offline. I am going to present different arguments of the American debate on hate speech. I use the American arguments because, as the previous speaker said, internet is local, is global, is one, but jurisdictions are local. The law is local, and then American legislation, American legal culture is libertarian, especially in free speech. And if we find some prohibit arguments in the American tradition, we can think that in internet these prohibit arguments should be better justified than in the other legal cultures, as a consequence, should be also justified. Okay, we have different points in favor of freedom on the internet. Declaration of Independence of Cyberspace. It's a declaration that says the rules of on cyberspace is freedom. There is different rules in cyberspace than in reality and offline. The Bill of Rights of cyberspace. No one may abridge our freedom of speech. The limits should be lesser limits. This is a Bill of Rights of cyberspace. And finally, the Bloggers Manifesto. The final words of the Bloggers Manifesto is, don't forget, in the end, the bloggers are many and the censors are few. We will not be defeated, we'll never fall silent. The online revolution has only just begun. On the other hand, we have criticism on the internet. For example, Umberto Eco, in his last book, criticized internet. He says that nowadays a great amount of foolish people has the opportunity to address a speech, to spread some ideas to a great audience. And now we can find on the internet non-existent conspiracies, denials, racism, and also fake news. The solution for Umberto Eco is education. He proposed that the newspapers should dedicate it more than 2 pages every day to inform the people what is a fake news, what is a real news. Okay, what is a hate speech? Definition from the from the Council of Europe says that hate speech is all forms of expression which spread, incite, promote, or justify racial hatred, xenophobia, anti-Semitism, or other forms of hatred based on intolerance. Okay, I am going to explain certain points in which internet is different from the offline world. One of these points is anonymity. On the internet, we can find people spreading rumors, spreading fake news, spreading hate, because no one can persecute these people. It's not necessary to give their names, their identification. Anonymity is a situation on the net. Another characteristic of the internet is the global local, as the previous speaker said. I want to explain the case, the Yahoo case. Is a well-known case of on internet issues. Is a case in which there is a Nazi auction on the Yahoo server. An anti-racist association from France claimed against this Nazi auction to prohibit this Nazi auction. Yahoo lawyer says, okay, the servers of Yahoo are in the United States. United States has a libertarian legislation that not prohibits Nazi auctions, not prohibits, generally speaking, hate speech. And then the law applicable is American, not French. This means internet is global, is one, and jurisdictions are local. And this is the great reality on the internet. Okay. According to a resolution of United Nations, the rights, the human rights, are the same online and offline. Is a resolution of United Nations of 2013. But the way that should be enforced, these principles can vary from country to country. And the question that we try to begin to answer today will be if is needed an evolution of human rights, of the human rights understanding should evolutionate with internet, with technology. Okay, my presentation. This was the context. Now we are going to discuss several arguments of the American debate. If these arguments apply to internet. The arguments are the intrinsic harm of hate, racist speech, harm to identifiable groups, harm to individuals, harm to the marketplace of ideas. These arguments are discussed in the article Racist Speech, Democracy, and the First Amendment of Robert Post. The first, the intrinsic harm of racist speech. Racist speech is morally wrong, and it's against equality. Then the question is, on the internet, morally wrong ideas should be prohibited. Ideas against equality should be prohibited. Okay, this is a philosophical question. Okay, my answer is John Stuart Mill says, We can learn from truth. We can learn for wrong ideas. We can learn from wrong ideas because if we have wrong ideas and mistaken ideas, we can compare with truth, and we can learn with a comparison with truth and wrong ideas. Then the solution is not prohibition, is not censorship. The solution is education, critically education. Second argument, harm to identifiable groups. The argument, this implies two arguments. Group libel. Group libel is the situation in which some people make a description of a group in a denigratory way. One example will be the Muslim in the Muhammad cartoons, which the Muslim wear the Muslim turban, was a bomb, meaning that the Muslims are terrorists. Could someone put a Muslim turban as a bomb, meaning that Muslims are terrorists? This is group libel. Okay, the question is, can we prohibit this in internet? Okay, one discussion is offline, but today we are saying, could we prohibit on the net? My point is, it's difficult to prohibit. This an image is so easy to spread image. We cannot prohibit. It is not a strong argument. Although there are certain cases in American law and certain legislation in Europe, but it's difficult to use group libel on the net. Also, the other argument is the subordination argument. Is an argument originally from McKinnon, but the argument is when you speak hate speech, you subordinate the people, no, the target group. Okay, I think this is alone. This is not so strong to allow prohibition on the net. But we are going to come to this argument later. Harm to individuals. Okay, according to the tort law in the United States, there are different torts that permit to punish certain situations of emotional distress or dignitary affront that could be regulated as tort law. I think this is justified by the formula of John Stuart Mill, harm to others. If there is emotional distress, if it's a racial insult on the net, should be prohibited, should be permitted. My point, should be prohibited. If someone harms an individual, this should be prohibited on the net. But my point is, we can prohibit certain expressions, harmful, serious, that can afflict certain expressions, the way of the expressions, but not certain ideas. The ideas could be expressed in a good way, but the point prohibited is the harmful expressions. The harm to the marketplace of ideas. Okay, the idea is racism is unconscious and irrational. Should be prohibited from the net. My point is, cannot be prohibited from the net irrational ideas, but could be prohibited from rational deliberation and from democracy. My point is, ideally, democracy is a rational debate. And then, rational ideas as racism should be out of democracy, should be out of rational deliberation. Could be eliminated from the net. I think it's not possible for the argument of anonymity, for the argument of global local. But the point is, what is the rule of emotions in politics? This is an open question. This is an open question, a huge question. Today we cannot speak about possibly about this, but it's an open question. Irrational ideas, emotions, have a role in politics? Should have a role in politics? Okay, I think it's an open question. But my point is, cannot prohibit irrational speech, but we can eliminate from rational deliberation and from democracy. Finally, another argument is silencing effect of hate speech. The argument of silencing effect says that when you speak hate speech, the next time you listen to the people from minorities, you heard quieter, you heard differently. you heard the people from minorities when you speak hate speech. You heard these people differently. Is a well-known argument on hate speech. My point is silencing effect, hate speech, and subordination effect combined could be a good justification to prohibit websites on the internet. Because if we have a lot of racist websites on the internet, a few websites with anti-racist content, this is not fair. It's not a good solution. Then we can prohibit certain websites, racist websites on the internet, and when promote the awareness of human rights on the net. Finally, conclusions. I think freedom has very good arguments, but in certain cases it should be justified to prohibit certain websites. The main arguments are harm to individuals, to promote a rational debate, and the silencing effect combining with the subordinating effect could be a good argument to prohibit certain sites of the internet. But finally, my main conclusion of all this speech is to combat racism on the net. The solution is education and no censorship. That's the point. Thank you very much.
Thank you, Oscar. Thank you for the very interesting presentation. So now we have Migle LAUKYTE. I hope I pronounced correct.
Migle.
Migle. Okay. She's also from Carlos III University. She did her PhD in the University of Bologna with a dissertation about legal regulation of intelligent computer programs. She was a postdoctoral researcher also in Bologna and then spent 3 years in EUI. She is, since 2015, Connect's Marie Curie Fellow, integrated in the project Allies. Her presentation is about the relation between artificial intelligence and human rights.
Thank you very much, Joana. Yes, I think I have to use. Can you hear me?
Yes. It's okay. It's okay.
Okay. So thank you very much for the introduction. As a researcher working for for many years on artificial intelligence, and especially as it concerns legal questions, my presentation is related to the new ideas on how artificial intelligence should be dealt with, how it should be regulated on the European level. So during my presentation, I want to focus on the latest developments on this question. So, but there is some background story that I want to tell you, so that it could help you understand the context of my talk. So first of all, many times when we speak about artificial intelligence, we speak about many things, and when we speak about when we are not particularly precise on what we have in mind, many times it happens that we do not know any longer what we're speaking about. So this is what happens to artificial intelligence, because when we use the term to cover a lot of programs, a lot of IT things, and the very idea of artificial intelligence, namely the idea that we could create a human kind of intelligence in the machine, is something we have discovered that it's not so easy to do. So as we failed in this attempt, we started to use the concept of artificial intelligence to name all the sophisticated and very great and very smart algorithms, but it's not an artificial intelligence in its original sense. So when we speak about artificial intelligence, and when I refer to this term here, I'm speaking about the big data-based algorithms, but I'm not speaking about something that we usually see in the science fiction movies or read about in Asimov's or other authors' stories. So in 2017, European Parliament has issued a document saying that besides many other things, that we need a civil law rules for the robotics. As you know, robotics are very much related to artificial intelligence. And in some contexts, robotics is an embodiment of artificial intelligence. So in 2017, the legal committee provided the European Parliament with a document saying that besides many other aspects, certain kind of autonomous and intelligent machines could be eventually granted an electronic personhood. And what happened then? There was a lot of negative feedback on this idea. So when we speak about the personhood, we do not want to think about the machines. We want to think about humans. And although many, in law, the beauty of law is that it is magic, right? That it can create things that do not exist. And we think about persons, when we speak in law about persons, we speak also about, not only about human beings, we also speak about the legal persons, namely corporations, organizations, political parties. This idea was not, the idea of personhood for the machines, as autonomous and as intelligent as they might be, was not something that sounded acceptable, morally especially. Because we know that legally almost everything is possible, but morally it wasn't something that we wanted to do. So how it is related, how this negative idea, negative approach to personhood of artificial intelligence is related to today's debate. Now, today we're speaking about the 17th anniversary of Universal Declaration of Human Rights, and we're wondering where are we going, right? What's next? And I heard my colleagues here at the table speaking about the internet, about the digitalization, about the new challenges, old problems and new problems. So artificial intelligence could be both, and surely will be both. A problem, a new problem, and a new solution maybe to some older problems. In the light of that, if we look at artificial intelligence as a problem, we should always look at it from the historical point of view. If during the first panel we listened to the historical approach to the development of human rights, and we heard about the slavery, right? Professor Davis from the US was referring to it, where the human being was seen as a property. So today we're coming to see a human being as an object, as a resource of data, and not as human, as a person, as something that we should, as someone who is entitled with the human rights. So after this enormous negative welcome to the idea of personhood to artificial intelligence in April 2019, so it's quite a fresh event, high-level expert group on artificial intelligence created by the European Commission issued a new document, an ethical guidelines for the trustworthy artificial intelligence. And there were certain things related to human rights debate that I thought could be interesting for us to look at. So these guidelines are made of. What these guidelines are actually saying is that the trustworthy artificial intelligence system should be legal, ethical, and technically robust. And the guidelines say that they are not dealing with legal issues, but they are dealing with ethical questions. That, at the end of the day, are very much related to the human rights, because we cannot speak about the ethically compliant tools or systems without having in mind human rights as they're listed in the international treaties and Universal Declaration, but also European Charter of Fundamental Rights and many others. So much so because we hear a lot of we assist a lot of ways in which artificial intelligence-based systems can be used to challenge human rights the way we understand them. So these guidelines list some of the human rights that should be foundational stones for any sort of artificial intelligence systems, such as human dignity, human freedoms, respect for democracy, justice, rule of law, equality, non-discrimination, because that is very, very important, and also citizenship-related rights, such as right to vote. And the ethical principles that the guidelines list and explain and are kind of standard bearers that bring forward the discussion, the very idea of the human rights as a foundational stone of any kind of intelligent program. So what these guidelines show us is the complete change of the position that the European Union is taking right now as concerns artificial intelligence. 2 years ago, there was the idea of legal personhood and of electronic personhood to the artificial intelligence was on the table. Right now, it's no longer on the table, and we're speaking about the human rights, and as the guidelines itself stated, a human rights-centric approach to the artificial intelligence. So as you can see, we have a kind of very, on the one hand, unstable, on the other hand, very, how to say it, very dynamic position on how we should look at artificial intelligence. And this is another thing that I think why these guidelines, why the debate is so important, because we are assisting the creation of new, also new human rights, because later on I will speak a little bit about the new rights that the artificial intelligence is bringing into being. But we're assisting of the works, we're assisting the work to create, to establish the position, the European position as concerns what kind of artificial intelligence we want to have. And I think it's a very important moment for the European citizens and not only. So the ethical principles are very much related to the human rights, as I said before. The principle of fairness is related to principle of non-discrimination, solidarity, justice, and equality, because we have already seen many artificial intelligence-based programs that actually discriminate the humans. One of the examples is the AI program used in the beauty contest that actually found that the beauty is can only be attributed to white women. And again, I always think that many times artificial intelligence is not discriminating us. We are who are behind these systems. So it is we who think that the beauty is white, or it is we that actually are inclined to discriminate on different parameters. So maybe sometimes what happens with the artificial intelligence systems is that they work as a mirror. So we see themselves in them, because this is what these systems learn from the human behavior. There are more principles such as explicability and responsibility. So we want these systems to be understandable. And there is also a principle of human dignity linked to the principle of human autonomy. So it's a very interesting principle, because on the one hand, we're trying to create as autonomous, our goal in the research on artificial intelligence seems to be to create more and more intelligent and autonomous machines. But we also want to keep that autonomy away from the human autonomy and not let these machines to decide for us, although many times we would like them to decide. So there is kind of clash between what we actually aiming to create. There is also some very interesting initiatives from the technical part especially in the Spanish companies that one of them, Alquilea, that created a program which is called Etica, which managed, so at the moment is able to not learn from the human behavior that many times is discriminatory, but it started to learn not to react to the discriminatory behavior and not to learn it. So this is something very important again in the artificial intelligence related research, because we are, it seems like we managed to program a human rights oriented rules in the machines. As concerns the new rights of described in the, not described, but coming out of these guidelines, there is the idea that there are two rights that these guidelines establish. First of all, that there is a right to be informed if you're interacting with a machine. So you have a right to know when you're not speaking with a human being. And it's also, you have an additional right to decide not to speak to the machine. And you have a right to choose to talk to a human being. And on the one hand, I thought that, well, it's great, right, that we try to ensure the human interaction for us. But on the other hand, I thought maybe it's very sad that we need that, right? Because these are new rights, but they also show new problems, that we might not be able to talk to other human being. And this is what all the technological advancements is all about. They should help us to live better. They should make our lives easier. But by making our lives easier, making them better, it seems like we might not be able to have a human interaction. So I think I'm almost, okay. And another thing that also it's quite coming back a little bit back to some of the points I raised earlier. There is a very strong emphasis on the human oversight of the artificial intelligence-based systems, and it comes a little bit. In a way it clashes with the very idea of artificial intelligence. Because we want systems that were autonomous. That means that they could work without us. They could do things without us. That they could help us do things we do not want to do, we do not have time to do. We want kind of helpers, right? But the idea that there should be a human oversight means that the autonomy of these machines will be always limited, because we want a human being to stand behind or above or close by and make sure that everything works correctly. So again, this is something that still needs to be explained, but and I think that these are only a couple of ideas that came out of these guidelines, and there is still work in progress, and new issues will come out of it. But what matters here is that we should keep an eye on technological advancements, because we've seen what internet made an enormous change, and artificial intelligence will not be less. Okay, thank you.
So we will now hear the question from our discussant, Tomasz Litwin, from the Jesuit University Ignatianum. Maybe you can sit here. No, you'll sit here.
No, I will ask the question from here. Well, first of all, I would like to congratulate to all panelists because of their very interesting presentation. I think the common element of all this presentation was that the digital revolution has the influence on the human rights. Well, but what kind of influence? Well, we talk about the dangers, the solutions, the challenges. And now I will have the questions to our speakers. Well, I will ask the question in the sequence of the presentation. I will have the common question to Professor Pérez de la Fuente and Professor SKRZYPCZAK. I think their subject were quite similar about the freedom of expression, speech, freedom of the opinion. Therefore, I have the question about the limitations of the freedom of speech, freedom of the opinion. I think it's the basic question when we talk about the freedom of speech and freedom of the opinion. Should there be any limitations? For example, Professor Pérez de la Fuente talked about the drawings of the Mahomet. They were published in the Danish newspaper. So, for example, should there be the limitation concerning the freedom of the opinion concerning the religion? We have, for example, in Poland the case of the Polish celebrity Dorota Rabczewska, who thought that Bible was written by someone who smoked something like the drug, and she was sentenced. And she had to pay something. So the opinion is not definitely smart, but should there be some such limitations? But also, if we talk about the hate speech, sometimes is, I think, the danger of the censorship, because we can regard the representatives of the minority as also the political community, who have the influence on the politics of state. So sometimes their behavior could be danger for the democratic system. Okay, I think that will be all. And the question for the doctor, for the Dr. LAUKYTE. Sorry if I badly pronounce your name. My question is, you talk about the autonomy of machines, you talk about the oversight and the autonomy. Sometimes I'm afraid if there shouldn't be a develop of the artificial intelligence in the some branches, as they could endanger, for example, the automatization of the work could be a danger for the human right to work. I have the doubts, for example, about the development of the artificial intelligence in, let's call it, military or police branches, when the machine could decide about our life. I mean, there are some. We cannot escape, I think, from the movie visions like Terminator or Robocop. So, should we, for example, like in biological science, tell that, oh, okay, maybe your research would develop something, but they are not acceptable from the moral point, so please stop, you cannot do this kind of research. I think it's all. Thank you very much.
Thank you. Can you please answer in the same order for the presentations?
Okay, I will prefer. Okay. Yes, very interesting question. Well, it's the key point. What is the limit? What is the situation in which is justified the punishment or the censorship on the net? That's a point. The first point is it's possible, technically possible. Second point, what happened with the local jurisdictions? As I try to explain, United States difficultly prohibits hate speech. In Europe, it is prohibited by the European legislation and by the national legislation. Is prohibit the incitation to hate. I am going to explain what is the situation in Spain. In Spain is very interesting. Hate speech, the incitation to hate speech is a crime, but the judge and the criminal law professors, the academy, the criminal law professors, don't want to punish for this crime. The judge is reluctant to punish for this crime, but the judge punish for victims of terrorism or offense to the crown. There are famous cases of victims of offense to the victims of terrorism or offense to the crown. And the problem with the hate speech is that with hate speech you punish the political dissenters. But I think minorities should justify the punishment of hate speech against the view of the judges and against the view of the criminal law professors. I think minorities has a strong argument, strong that the terrorist victims, strong that the crown to be punished, and the law should be enforced. That's my personal opinion, my academic opinion on the question of hate speech.
Thank you very much. Thank you for your remarks and questions. You questioned about the influence of digital revolution of freedom of speech, on which level, dangerous, solution, challenging. In my opinion, on the all fields, we can find such influence, because we can find old dangerous and the new completely solution and challenges also. Yeah, so it means I metaphorically mention about discovering a new continent or the new parallel world. So, because in my opinion, this space, this is the new parallel world. Yeah. Limitation. Well, in a philosophical sense, the answer, where is the limitation of freedom of speech, is, in my opinion, very easy in analog and digital era. This border is in this point when starting your freedom, your space. Yeah. However, how find this border in the practical issue? Yeah, and why during on this digital space this is so important, because sharing of contents, we have we can observe a huge or big steps on this field. Yeah, everyone could be a broadcaster, sender. Everyone. I guess that even during this conference, someone of you sharing the information, I hope, from this conference. So it means that while problems with freedom of speech we can observe on the huge scale. According, I'm sorry, you mentioned about this problem, global and local responsibility. So this is a also problematic case, because I agree with you that, for example, from Europe point of view, American, etc., Google and, for example, Facebook is most popular services. However, you must remember that, for example, in Russia countries, Facebook is not so popular like VKontakte, no?
It depends.
Yeah, for example, in China, the most popular searcher, internet searcher is not Google, Baidu. Yeah? So we can say, of course, that this is also local responsibility, but not in United States, but in China and for example, Russia. This is a problem, but I agree that the best way is good education. However, I'm a lawyer also. Well, so question is this effective way of fighting with hate speech or disinformation, etc.? I'm not sure. Yeah, I'm not sure. So, okay, thank you very much.
Thank you.
Okay, thank you very much for your question. And your question has many layers. And I think what matters here is that we should distinguish autonomy from automatization. These are two different things, right? So automatization happens with the human control at the end of the day. And the goal that the automated system is trying to achieve is established by a human being, whereas autonomous systems decide in theory, because we do not have such autonomous systems, decide on their own what they are trying to achieve. And as concerns the work and the change in the job market and in occupation, I do think that it is maybe, in my personal opinion, that maybe we are seeing it quite too tragical, because we have seen many changes in human history and we reinvented ourselves. And we substituted horses with cars, and we made a lot of things. And you just think about 10 years ago, we would not be sitting here with our, like 15 years ago maybe, sitting here with our cell phones and connected to the Wi-Fi. So we adapt quite quickly. And I really think that the point is, as my colleagues also said, it's education, training, requalification, and we can somehow deal with the issue of work. Also, another thing, as concerns artificial intelligence, there are a lot of new kind of jobs that are being created. And someone needs to test the exoskeleton, someone needs to test the program, someone needs to teach the programs how to do things. So I think there are a lot of new jobs opening in the future. And as concerns the police and the war, well, police already is using certain artificial intelligence-based system for traffic control or for crime prevention. And also I know that the Spanish police was testing an artificial intelligence-based system to establish whether the woman calling a certain telephone number is being, whether she really has a problem at home and she's being abused. So there are many useful ways of use artificial intelligence for ensuring human rights as well in this sense. On the other hand, as concerns war, of course, I would be against using autonomous weapons, but not because of the weapon, but because of the war itself, that I think is immoral, should be illegal, and should not be there. And I sometimes think that there is a lot of hypocrisy in the issue in the whole debate on the weapons, because as if we are saying that it is more correct if people kill each other rather than we do it with the autonomous weapons. But the killing is illegal. The killing should not take place anywhere. And I think what should happen with autonomous weapons, they should be banned, and we already banned biological weapons. We banned many different kinds of weapons. So I think we should do the same with the autonomous weapons as well. The thing is that many research came out of the military research. Many useful things, internet as well, came out of the military research. So the issue is that we might miss some useful applications by simply banning the whole enterprise. So that's a bit my answer.
Thank you. Now we will have some questions by the public. Okay, so 3. Can we start here, please? Do you have a question? No? Not yet. No? Okay.
Okay. So my question goes to Professor Pérez de la Fuente, to whom I would like to address all my congratulations, because your intervention was really interesting to me. Also, you know, we share the interest for this topic of research, and so you focused on the harm principle basically in addressing questions coming from the legal debate and hate speech. And so my question is as follows. Are we sure that the harm principle should be a cornerstone for reflecting in hate speech in relation to state intervention? And this is why I ask this. To my mind, to my view, this kind of reflection on the harm principle as a tendency to conflate the idea of state intervention with criminal intervention, as we were discussing earlier. And what I think is that the harm principle, as all legal philosophers and criminal lawyers know, is the basic principle for criminal intervention. I would argue for state intervention and states addressing the problem of hate speech on a different basis, which is not related to causing harm to others, but contributing to the social subordination of victims, which might or might not be measured under a notion of harm, because there are like possible effects of subordination which are not concrete and not imminent, and therefore could not be described under the harm principle. So I would like to know, what is your opinion on the this thing? Thank you very much.
Thank you.
Yes, my question is for Professor Oscar Pérez, and I wonder if it is possible to justify the limitation of the freedom of speech, stating that the human rights are not absolute. Even the right to life is not an absolute right. And another point is that in USA, for example, it's not a real freedom of speech, because if there is a person who offends the national identity, this offense is a felony. I would like to know this, and but also it is if it is possible to justify the limitation of freedom, stating that the human rights are not absolute. Thank you.
Thank you. We can take one more question for now. No? You can answer. Oh, yes, of course.
I would like to have a question, or I would like to challenge maybe our host. You, in your presentation, you concluded that the answer to hate speech is education, not censorship. Now, if you say education, you assume that better education would help, or that, well, that education in a sense can resolve this problem. And I think that since the beginning of liberalism, the stress is put on education to resolve all sorts of problems which we have, and somehow I think that we are much better educated today than we were 200 years ago, and still we deal with similar problems. I think that this belief that education can resolve most of our problems lies in the fact that we still subconsciously believe that we are only rational beings, and I think that the problem is that probably we are mostly irrational, and that is why more education wouldn't change anything, because I can easily find examples of excellently educated people who at the same time resort to hate speech. So education is not, I believe, not a viable solution. It might help. The other thing is that I think that it's time to discuss the question of the interpretation of freedom of speech, because when this principle emerged, when when the authors of that idea had political speech in mind and freedom to express one's opinion, which later on, as you some called it, through libertarian interpretation by America, it was applied to all sorts of speech. Starting, well, originally political speech, but then pornography, and now everything. So, and of course, the problem is that America, as a superpower, can impose their rules and regulations on others. And I think that we are, in a sense, all in this sort of dilemma that on the one side we deal with all sorts of problems in the internet, especially right now, but not only. And at the same time, we are imprisoned in this American perspective that any speech has right to be expressed. I don't know if you can comment that or respond.
You can answer the questions,
Okay,
please.
thank you for the questions. Very interesting. Yes, the first question. Yes, I think the principal harm to others is a good principle in cases of hate speech or cases of speech. Yes, there is another principle that is used in the literature about social subordination, and it could be a good argument. But in my presentation, I have to think better. But in my approach, in my presentation, I think the subordinizing argument is not sufficient to prohibit websites on the internet. But jointly with the silencing effect argument could be a good argument. The subordinizing argument came from a feminist, from Catherine McKinnon, from Only Words, and it's applied to pornography. And then says pornography subordinates women. And then other scholars apply this argument to hate speech. Yes, I think it's interesting. Yes, hate speech subordinates people. Yes, but I think for the specificity that we have talked different points of a specificity of the internet, I think it's not sufficient to prohibit different websites of a subordinizing argument. Otherwise, pornography should be prohibited of the internet if you use this argument. If you use the argument of subordination completely, coherently, pornography should be prohibited of the internet, and I think is not the case. The second question about the absolute right, about if there is an absolute right of freedom of speech. Well, there is a paper of an American scholar that says United States versus the rest of the world. And when I teach my students of the American cases on hate speech, my students that are mainly Spanish but are also foreigners, but when I explain the cases Sochi or Rap versus St. Paul, the case Sochi is a case of a Nazi demonstration in a Holocaust survivors area that it's permitted by the Supreme Court, American Supreme Court. My student says we don't understand this. And Rap versus St. Paul, the Supreme Court says is against the Constitution or a regulation that prohibits a burning cross in the garden of a black family. And when I explain this to my student says we don't understand this. But we have to understand the American mind, the American approach to free speech, and we have to have all the elements. And in the American, there are things that neutrality of content. And the neutrality of content means that the Supreme Court is not in charge of saying if an idea is right or wrong, is the market. Are not the judges who are going to expulse an idea of is right or wrong, is the market. It's a competition with another ideas. It's a marketplace of ideas. And finally, the education. Well, I think, yes, it's interesting what you said, but I am going to put you an example and I make a point. An example was a debate in Spain when Europe's bookstore is a famous case in the Spanish case law. Is a bookstore in Barcelona with Nazi anti-Semitic, racist, far-right material. Okay, I was in a debate with a law professor, a civil law professor, constitutional law professor, philosophy of law professor. Each scholar tell their opinion, and one of them says, the solution against this bookstore Europe is not prohibit bookstore Europe. The solution is that the people should read a biology book. And then if you read a biology book, you know that races are not, are scientifically refuted. It's not true that one race is superior to other. This is scientifically true nowadays. Then the solution, I think, is not prohibit websites. Generally speaking, there are arguments to prohibit when there is harm to individuals, when there is silencing argument. There are good arguments to prohibit, but generally speaking, the solution is to educate the people. Another point that I want to make, and it's connected with something that you said that I think is very interesting, is the point that different countries has different regulations on internet. For example, I attended a seminar from LAUKYTE about new technologies, and the idea, it was very interesting because I thought when I attended this seminar, the idea of democracy that different countries have is reflected in the internet regulation. And this is very interesting because we can think in China, we can think in America, and we can think in Europe or Russia, and possibly the political system is reflected in the internet regulation. I'm not very sure of the details, but I think is the regulation on if you could publicize, if you could speak, if you could put some your opinions, political opinions, political dissenter opinions on the net. Possibly it's not the same in China, possibly it's not the same in Russia or in the United States or in Europe. And it's connected with the notion of democracy, with the notion of the political system. And well, it's only a point, it's only a thought that I made from your seminar.
Maybe we can take one more question. Anyone? No?
Focusing on the U.S., we kind of avoid the obligation to protect rights. And with the talk of education, perhaps there's a link there.
No, please use the macro.
Yeah,
use the
okay,
macro.
so perhaps there's a link there in that if we're going to say we need education to balance the liberal side of hate speech on the internet, allowing this to occur, shouldn't states be obligated to do the educating? Controvert the hate on the internet by publishing their own stories, their own contradictions, their own truths on these points, or at least fund it, so that they're offering grants to groups who want to put out anti-hate speech, because otherwise the only voices being spoken are those who are putting the hate out there.
Thank you. Nobody
I
wants
completely agree.
to...
Yeah, completely agree. Yeah, of course. Yeah.
We're over? I think we're all hungry. So we'll be back at 16, right?
Yeah.
4?
Yeah.
So thank you all to our speakers and to our public. Thank you.
Thank you.
Excellent, very interesting. Yeah, it was very, your
This is
paper
very
was
far
very
from
interesting.
what I do, but it was very interesting.
Are you